Hello, my name is Gerard Ryan. I'm an attorney at Parker Waichman, and today I want to talk to you about depositions, or what we call them in New York, the examination before trial, or EBT. So first of all, what is a deposition? Depositions are statements that are taken under oath, that are transcribed, and can be used at trial. This is the defendant's opportunity to ask you questions and investigate the claims that you've made against their client. In this video, I want to give you an overview of what to expect and some general advice that I tell my clients before they have their depositions. I'm a plaintiff's attorney, so this video is going to be geared towards plaintiffs, or in other words, the person who initiated the lawsuit. Before I do that, though, let me preface this by saying that when I have a client who's going into a deposition, there's usually an extensive amount of prep that can last hours or even days. If you have a deposition coming up, make sure you contact your attorney for specific guidance on your case, and don't just rely on this video. So, what do you expect on the day of the deposition? First, depositions are usually not conducted in a courtroom. You'll most likely have to go to an attorney's office or some court reporting service. Secondly, when you walk in the room, there's going to be a few people there. First of all, there's going to be your attorney, who's going to be with you, and then there's going to be a defense attorney or multiple defense attorneys, depending on how many defendants are in the case. Then there's going to be a court reporter, who's going to transcribe everything that you say into a record. Now, there are occasions where depositions are videotaped, but it usually isn't the case. You can always ask your attorney whether or not your deposition is going to be videotaped. So, the first thing that's going to happen is that the court reporter is going to swear you in. So she'll ask you to raise your right hand, and you'll swear that you'll testify truthfully. And at this point, you are under oath. And while you aren't in a courtroom, your testimony has the full force and effect as if you were. The defendant's attorney will start asking you questions. But first, he's going to cover some ground rules. Everyone who's conducting a deposition covers these ground rules. Even I cover these ground rules. It just ensures there's going to be a smooth deposition for people who've never been deposed before, which you most likely have not been. The first rule is that because there's a court reporter there, everyone needs to speak one at a time. It's normal in conversations to sometimes speak over each other, but you don't want to do that here because the court reporter won't be able to get it down. The second rule is you need to have all your responses be verbal because the court reporter can't take down a nod of your head. Third, if you don't understand a question, it's perfectly okay to say that and ask the attorney to rephrase it. And the fourth rule, if you need a break at any time, you're free to ask for one. But you have to answer whatever question is pending. A deposition is not a marathon, so if you need a drink of water or a bathroom break, just ask for it. Now, fifth, don't guess at any answers. If you don't know something or don't remember something, it's perfectly okay to say so. Just make sure that you understand the difference between I don't know and I don't remember. You generally say I don't know for something that you never knew, and I don't remember for something that you just can't recall now, but knew at one point. Now, your attorney's going to be sitting next to you and will occasionally object. But if he or she isn't objecting, it's okay. In New York, objections are reserved for trial, so your attorney will most likely be objecting to what's called the form of the question. There are rare circumstances where your attorney may instruct you not to answer a question, but there needs to be a basis for this, such as attorney-client privilege. So that's what to expect when you get to the deposition. But before I wrap up this video, I'd like to give you some advice that I give my own clients before they go into a deposition. So if there's one thing that you take away from this video, it's that you need to be honest. At your deposition, you need to testify truthfully because you were sworn under oath. Now, no case is perfect, but that doesn't mean that you can change the facts once you get to your deposition. Second, focus on the questions and only answer what's asked. Most questions can be answered fully with just a yes or no, and when you can do that, you should. Don't go off on tangents, because when you go off on tangents, not only do you open yourself up to additional questions, that testimony will be used to lock you in at trial. Third, while the person asking questions is not on your side and trying to fight your claims, you need to be polite and show them respect. Whoever's defending the case is just doing their job and it's not personal. Plus, sarcasm and any kind of attitude can look terrible on transcript and it won't help your case. Fourth, Regardless of whether or not the deposition is videotaped, you should dress in at least a business casual attire. And finally, stay calm. If you've been injured by another person, you have nothing to hide. Just tell the truth and focus on the questions. So that's a general overview of depositions. And like I said before, this obviously isn't inclusive of everything. Your attorney will be able to tell you additional details about your case. If you have additional questions about depositions, or you or a loved one have been injured, please give us a call at the number at the bottom of your screen. We can give you a free case assessment and let you know the best course of action to take. Once again, my name is Gerard Ryan. I'm an attorney at Parker Waichman Law Firm, and I want to thank you for taking the time to watch this video. Have a great day and stay safe.